Hello and welcome to In Conversation with Kashmir Times. I'm Anuradha Bhasin, and joining us today is Senior Supreme Court lawyer Vrinda Grover. And we'll be discussing the High Court, Jammu and Kashmir High Court bail to journalists Fahad Shah and Sajjad Gul, and understand the significance of the observations made by the court, particularly in the context of freedom of expression. Now, let me begin first with one of the cases, which was against Sajjad Gul. It was said that he reported giving eyewitness accounts of an army encounter and then tweeted the story. And while the J&K government or the investigating agencies alleged that Gul's tweets could be used to provoke the people against the government, the court said that this cannot be grounds to claim a true and factual media report. To claim that a true and factual media report can provoke people. Can we then say that the court is making a clear distinction between criticism and provocation, and that any criticism of the government or reporting that is not in line with the official version, it cannot be deemed to be a threat to law and order? And can true and factual reports be criminalized?
I just missed the last part. What did you say in the end? You froze for
I
half
said
a second.
that while the court is making a clear distinction between criticism and provocation, and saying that any criticism of the government or reporting which is not in line with the official version cannot be deemed to be a threat to law and order.
I think what the court has made clear is that journalists have an important role to do. It's their professional role and job to report what is happening, whether it is in the course of daily life in Kashmir, it is in the course of an encounter, or it is in the course of a protest. The job of the journalist is to report what people are saying, what is transpiring, what is the activity and the actions that are happening on the ground, which is what was reported. Now, simply because people are saying things which the government does not find palatable, or which the government disagrees with, or which does not fit into the image that the government wishes to project, what is then would be required for a journalist actually to do is to simply take an official handout and to post that, whether on their in their newspaper or on their social media handle. If a journalist is actually going to report what is happening on the ground, and if people are raising slogans or people are expressing any kind of protest, and that is reported, that this is what has transpired, then that is really, one would say the journalist is doing their job accurately, professionally, and honestly. And to say that that may lead to provocation, may cause incitement, and therefore to put people under preventive detention, is obviously ways in which the state has been, and in Kashmir that is not new. It has been a long, many decades now of various forms of silencing that has taken place. And the media, the court has always stepped in and said the role of the media is particularly will be called the fourth pillar. Their work will have to be seen through the lens of, one, their professional job, and secondly, to see that is it falling within the purview of freedom of speech and expression and freedom to practice one's profession. So the court has to always see that when the state is saying that, you know, somebody is committing an offense, or somebody is inciting or causing public, how do you balance that with constitutional rights? And in this case, the court has very clearly held that this is part of a process in a democracy, and that simply because it does not tally with the official version cannot be deemed to be any form of provocation or incitement.
Yeah, and similarly, you in Sajjad Gul's case, we're talking about reporting and professional obligations. In the Fahad Shah case, which is related to an opinion article written by Ala Fazli, the court has said, while the state investigating agency said that this was, to propagate false narrative and it was tied to the secessionist campaign. The court has said that while the opinion piece called for secession of Jammu and Kashmir, it didn't incite violence or an armed insurrection against the state. And the court has observed there was no evidence brought on record that the offending article was responsible in provoking people to take to militancy. So here too, do you think the court is again in terms of, when it comes to expressing opinion, there is a clear distinction that is being drawn between writing about secessionism and terrorism, and actually provoking violence?
Absolutely. I think the court is very clear. And this line of judgments is actually drawing the line for the state, which the state seems to trespass constantly. And is saying, and we have to remember that this so-called article, which is at the heart of the controversy in the Fahad Shah case, is an article allegedly of 2011, which is not
Yes.
even on the Kashmir Wala's domain. And it was, in fact, resurrected. Through investigation, they found this article. It was not available in public domain. If anybody would have Googled in 2022, they were not going to run into this article. This article was, they said they received some information, and it is the case of the prosecution that, yes, that they have deliberately, to avoid detection, it has been removed. And the court said, well, your own case says that there is some attack that happened on their server, and thereafter this is no longer available. So to say that something that was perhaps written in 2011, and it is entirely up to the state to prove everything. It is no part of the persons who've been arrested to prove anything. That something written in 2011 is radicalizing people to take to arms, and is therefore there is a need for an arrest in 2022. So the court is saying what is said in that article. The court then goes into that and very clearly says that while it may be talking of people wanting to have their own distinct state, they are not even talking about joining any other country. And they're definitely not talking about picking up arms, nor is the article asking anyone to pick up arms, nor is there any evidence to show that anyone has said, oh, I read this article and I got so motivated and I decided I'm going to pick up arms and I'm going to, become a militant. There is absolutely nothing there. And clearly the court is saying, look, this space of freedom to speak and express diverse views, dissenting views, views that the state may not agree with, is not a space that should be criminalized.
So what would be the implications of such observations by the court on other cases, where you see journalists, critics, dissenters in Kashmir and in other parts of the country being framed in different cases for what they are saying or what they are writing? Would it have a bearing on other cases?
Of course, because I think these are very well-reasoned judgments. These judgments are actually taking into account the law. They're taking into account examining the words that are being used in very, very carefully. Very, very well reasoned, and are drawing the line between it is trying to say that there will be only one meta narrative. And the court is saying, no, people can have different views. You may not like what they say. You may not agree with what they say. But until and unless the relationship and the direct link between violence, incitement to violence, the clear and present danger is made out. This cannot be criminalized because people will have a fundamental right to speak, and it's very clearly preserving the domain of freedom of the press. More particularly, not just freedom of speech and expression in general, but the court is very conscious of the fact that in both these cases, the persons who are facing incarceration are actually journalists.
Yeah, but how does it really pan out in real life? Because a day after Fahad Shah's verdict, Jammu and Kashmir's Director General of Police, he spoke about writers who are hiding behind freedom of speech and expression, and whose writings he believes incite youth to pick up arms. And he talked about writers who write differently, whatever that means. So what do you really make of this?
Well, you see, what is the court's role in the way our democracy is structured is the state clearly wishes to push a certain official narrative and absolutely does not want to leave any space for any, even forget a dissenting or a contesting view, even a diverse view. And we know that even from the Kashmir media policy that was put out, it was very clear. So the state wants that there will be only one singular narrative. And history shows us that states have often attempted to do that across the globe, to create one singular narrative, which is the narrative of the state. And it clearly it seems to be some kind of a desperate attempt by the state to think that if we put out one narrative, people will only think what they read and hear. And as we know, and again, history tells us that that has never been true. And there will be multiple ways in which people will think. And the court is saying, we will have and protect. What I think is important from what you're saying of what the Director General in charge of the media, etc., is saying, and I think this is something we are observing everywhere, not only in Kashmir. Is the state observing the rule of law anymore? Is the state adhering to the principles and the mandate of the Constitution? It appears that the state is repeatedly departing from adhering to rule of law. And it's actually been left to the citizens to repeatedly knock on the doors of the court, due to which people are then incarcerated for very, very long periods before they are released, even if the court were to say that, no, there is no crime that has been committed, he's simply doing his job as a journalist, they have nonetheless lost their liberty for a substantial amount of time. They face criminal cases, and this kind of state action has a larger chilling effect and intimidation, not only for journalists, but for all persons. And people are very cautious and careful in how they speak and what they say. And I think it is really about pointing the finger to the state, which must which is actually takes the oath of allegiance on the Constitution to subscribe to that.
Yeah, I I don't know if do you think that this will continue? They may continue to press for similar charges in other cases. And if you look at the DGP's statement, that is an indication, that gives us one indication. But going back to the kind of absurdities that the court has pointed out in Fahad Shah's case, the investigating agency stated that the views in the article are extremely insidious and one that is shared by secessionists. So is there an attempt to accuse a person of thought crime? And this might not be the only time that the state has taken such a position. If you remember, in the Mia Qayyum bail case, the bail was denied to him because he was accused of a separatist ideology. So how dangerous can such arguments be?
Well, I think it links to what we were just discussing prior to this, that the state The state project seems to be that there will be one narrative, there will be one way in which life, history will be understood, and everyone will have to subscribe and adhere to that. And if you think differently, there's also reference in that in the Fahad Shah order, for instance, of some unpublished poems.
Yeah.
But if I were to, in my private space, write something, and these are unpublished, which means I'm not putting them in the public domain. I'm not asking people to read them. I'm not didn't even find those anyway seditious in nature. The court thought it was perfectly fine. He about Kashmir and how he thinks of Kashmir, and the travails that Kashmir has historically had to endure. So there is clearly an attempt to, and which, as I said, is a desperate attempt by any state, and no state has ever succeeded in doing this across world history, to say that you will not have a viewpoint which is different. You will not have a set of events differently. And whether it is thought policing, whether it is controlling what is published, it is through the weaponization of law that all that is being done. It is being done by deploying laws like UAPA, certain provisions of the Indian Penal Code, of course, the Public Safety Act, which has been much critiqued for years now. And it is through the weaponization of law that fear is sought to be instilled. That if you will write, if you then you will have to go behind bars. Fear has never been able to control human imagination, and but always attempted that. This kind of instilling of fear, yes, it has. I'm sure it has some dividends, and we do see people changing what they're saying. People stances, but you're going to persuade people to live in a certain way, agree to a certain thing simply through fear would not work. And I suppose it would only become more and more subversive, and it would take more subversive forms of expression because people will continue to think in different ways.
And
It is very dangerous.
And in these cases, I mean, if you look at the Fahad Shah case, and if you see even Arundhati Roy's case, which goes back to 2012. So what somebody said in the past, maybe 10 years ago, 20 years ago, that is going to be weaponized. There is a likelihood of that. But let me,
it is actually to have that, because it is an attempt, actually, it's not to silence just that person, it's to silence everybody.
And thank you for pointing out, that they live in perpetual fear. And that really seems to be the case. I've noticed, people now a little scared of what they wrote years ago, and they're trying to erase the signs of the digital footprints of whatever they wrote years ago. But moving to technicalities and looking at the article that was written and published in 2011 in the Fahad Shah case, the court has held that the government dug out the case against him after he had already received bail twice from different courts in Srinagar and Shopian, and then he was taken into preventive custody under the Jammu and Kashmir Public Safety Act. So the court observed it was in this backdrop that the current case against the appellant was dug out by the respondent with the registration of the aforementioned FIR. And this seems to be a familiar pattern in many cases. If the government wants to persecute someone, more cases will be dug out. And as we just mentioned, the Arundhati Roy case, or they would be concocted so that the person can be kept in jail and out of circulation. So how significant would these observations of the court be for other cases?
No, these are very important orders, because we know that there is a revolving door that PSA, for instance, creates, that a person is, you get bail in one, and before you don't come out of the prison, before that you already have other cases, and it's what we call the evergreening of custody that the state undertakes. While we do see that there is these orders of this nature, they are saying, regardless of UAPA, regardless of the strictness of the law, we are going to examine whether there is any need for arrest, well, what is the circumstances of arrest, whether there was any clear and present danger. Unfortunately, what does happen is that we don't, by the time these matters reach, after all, this order has come from the High Court. In many cases, we see, for instance, in the Mia Qayyum case, you would recall, the order eventually came from the Supreme Court. A long period of time passes. And as you said, it is to keep people out of circulation. And a person who has suffered an unjust incarceration, and the case is not over. Many of the sections have been quashed in the Fahad Shah matter, but some sections and the criminal trial will continue. So it's not just about keeping you out of circulation, it's about having ensured that now you will not speak. Because they were unable clearly to keep him in prison in whatever other cases had been put on him, and he was getting bail, and the preventive detention was then quashed. This case was actually, as the court says, they found this article in order to create a case and put a case under the Unlawful Activities Prevention Act, which is the most draconian of the anti-terror laws that we have in the country. And while these are very positive signals, will it at all deter the police or the state or any other agency of the state, investigating agencies, from making similar arrests? I would not be very hopeful. Will the Sessions Court, which is the first court which deals with cases of the Unlawful Activities Prevention Act, will the Sessions Court feel encouraged and say, all right, this is the jurisprudence that the Supreme Court and the High Courts are setting, and I will not entertain matters of this nature. I will immediately either award bail or quash charges. I'm again not very confident that that will happen. I think these continue to be, these are not routine orders. These are glimmers of hope we get, but the state is able to, through its huge resources, put out a narrative about a case which overawes all institutions and tends to color public imagination. Most people don't know the nitty-gritties, which is the article, what is the article. All they know is, oh, there is another Kashmir editor who has been arrested. And that's all the narrative that the state wants to project. So I'm not very, I think we have good, there are good foundational stones today to be able to counter the manner in which UAP was perceived. If you go down UAP, you will not get bail. I think that has been demolished, both through judgments here that we are discussing, as well as other judgments, particularly in the Bhima Koregaon conspiracy. But are those sufficient for such kind of malified and arbitrary arrests to halt? I would be very doubtful.
Hello, can you repeat that?
Suffering and through incarceration is continuing.
Could you repeat the last part?
I said, I'm not sure that we've reached a place where this jurisprudence is now taken on board as the norm, which has been the jurisprudence of this country, of bail, not jail, etc. I think the implication particularly of journalists and activists and their incarceration will regrettably continue. And in each individual case, one will have to struggle and come to superior courts, constitutional courts, to get these breakthroughs. And we have to remember that actually everybody may not even have the resources from different parts of the country to be able to come forward.
In the Sajjad Gul case, the court points out that even the detention orders were pretty vague, and says that it appears that the detaining authority has passed the order of the detention against the detainee on the dictation of the police. So is that telling us more about the kind of system you're talking about? It's not just the investigating agencies of the state, it's also the detaining authority, and the system keeps going up. And as you said, there are very few glimmers of hope from the courts right now. So
that is the purpose of that narrative, which is meant to overwhelm and overawe everybody.
And the due process of law then becomes the punishment, right?
The law takes long. People suffer, and those who cause the suffering face no consequences.
So what can and must be done to change that? Should there be clear guidelines that the courts should be giving? Should there be punitive action against officers abusing their positions to ensure that different processes are not weaponized against the accused? What can be done to change this way?
Multiple levels change needs to be brought about. If you were to see Section 13 of the Unlawful Activities Prevention Act, it is so broadly worded that just about anyone and everyone can be brought within the purview of the UAPA, which is the provision that survives even in the Fahad Shah matter, because it says anyone who advocates, abets, advises. So these are very overbroad terms. Yeah. And where does the criminal activity begin and freedoms end will then become matters of trial and detail. Similarly, you have courts, the minute there is UAPA and such, or provisions of IPC which talk about waging war against the state, etc., courts are very cautious, and the state already does a little media jamboree where they are able to show that, oh, they've picked up this person who's causing secessionism, who's inciting people, and there is a projection that is done outside which does permeate and does influence, and it's done with absolute impunity. There is no price to be paid. Even after trials we've had in this country, courts have acquitted people on death row, and courts have said they have been falsely implicated. But has any person been held responsible? Has anyone had to pay any consequences for this manner of abuse and arbitrary use of power? Until and unless that turns, and there I think the courts will have to think that the state, you see, in this country, I think what we have lived with, and Kashmir has shown us this much earlier. Now the rest of the country is seeing this in different ways. The entire legal system is structured on a premise that the state and its agencies, particularly the police, the investigating agencies, are going to act in good faith. If that premise is no longer true, then how is the system working? What is the court working with? So we are dealing with very serious structural issues today, which we have to, I think, because people who are suffering, the state is able to paint them in a certain way. The whole
demonize
of society
them.
has not yet understood that this. Yeah, and the rest of the society doesn't think this is necessarily an an issue of concern for democracy. They continue to think these are some individuals who have to deal with these problems. But I think this is an issue of concern for any democratic process to be sustained.
And for democratic process to be sustained, we need kind of change of laws. Like in Fahad Shah's case, the court has said that the police have unbridled powers to make arrests under UAPA, the Unlawful Activities Prevention Act. But they have to justify the need for making these arrests. So does this underscore a need for adequate, guidelines or even amending
in the
UAPA?
Fahad Shah UAPA, definitely much of UAPA needs amendment. Even in the Fahad Shah case, they are relying upon an earlier case of Joginder Kumar, etc. So it's not as though these legal doctrines are not understood, that arrest is to be made if there's a need to arrest. What is the clear and present danger? It's actually laughable at one level. An article allegedly written and published 11 years ago. In 2022, what is the danger from that article that the Indian state or anybody else, is it going to excite, particularly an article that is not available on the public domain? You have resurrected it for whatever reason, which only the state knows why it is wasting public resources in this manner. So clearly, this whole power of arrest that the state is given, again, as I said, it's given because there is a presumption that the state is going to act in good faith. But if the state is acting for extraneous reasons, then these powers need to be diminished. And the state cannot have this kind of power. And the law of bail in this country requires an overhaul for all crimes, this whole business of keeping people in jail. And even courts have said this, that, oh, the process is the punishment, but then how are we going to undo that punishment? So, it then the fundamental right to life and personal liberty, it makes a mockery of it. I think in this country, courts need to completely set out the bail jurisprudence. If trials do not commence in X time, if trials do not conclude in X time, put people out. State, if it wants to, if state thinks somebody is a terrorist or needs to be arrested or needs to be kept behind bars, state has to prove. Today, the state is not proving its case. In most of the cases where people have been picked up, the state is never actually proving its case against them, because the state's purpose stands served by just keeping people behind bars as under trials.
Thank you very much, Vrinda. Thank you for joining us today.